Welcome to MITRE's second annual Data Privacy Week panel discussion, the EU-US Data Privacy Framework. One of the top issues in data privacy and security this year is the long-awaited compromise on the EU-US Data Privacy Framework, a framework that leads to adequacy for the US in the eyes of European regulators. Put simply, adequacy is the means by which the US is classified as acceptable to handle personal information for EU data subjects. But it's so much more than that. Adequacy for the US equates to certainty, certainty for US businesses, certainty to EU citizens and residents, and certainty that US privacy laws and protections are comparable with the most revered privacy law on the world stage, the GDPR. This is a complex topic with opportunities and challenges to consider as we navigate the latest iteration of an acceptable regime for EU-US personal data transfer. Hopefully, the third time's a charm. I want to take this opportunity to thank everyone in advance, our talented panelists for their commentary and participation in the event today. Each of them brings a unique perspective in the proposed EU-US data privacy framework. At this time, I would love to turn it over to Dina Kozanis, MITRE's Associate General Counsel and Chief Privacy Official, and she will moderate the remainder of the event. Over to you, Dina.
Great. Thank you so much, Julie, for those opening comments. Good afternoon, everyone. Like Julie mentioned, my name is Dina Kozanis. I'm an Associate General Counsel and Chief Privacy Official here at MITRE. I'm also the Director of our relatively newly established Center for Data Privacy and Protection. I want to welcome everyone to MITRE's Data Privacy Day event. A couple housekeeping items before we start. This session is being recorded and it will be available on MITRE's YouTube page soon after the event is over. Also, we welcome questions from the audience. There should be an avenue for you to ask these questions in a chat box to your right. If you feel obliged to do so, please offer your name, first name only is fine, and your organization so our panelists have some context as to your question. And finally, if you have any comments or questions on the programming, feel free to contact MITRE afterwards at privacy@mitre.org, and we will provide that email again at the end of programming. So let's continue. We have a great panel assembled to talk through the opportunities and challenges in this latest iteration of a data transfer agreement between the US and the European Union. Our talented panel spans all sectors involved in this debate: government, private sector, and civil society. And for their full bios, please visit our registration website. They have a lot of accomplishments, and I don't want to take up too much time listing them all, but I will tell you their names and their current titles as we continue on. So first we have Beth Williams. Beth is a board member at the Privacy and Civil Liberties Oversight Board, or PCLOB as it's referred to. The PCLOB is an independent agency in the executive branch. Next, we have Jackie Acker. Jackie is a Deputy Privacy and Civil Liberties Officer at the CIA. After Jackie, we have Nicole Sterling. Nicole is a partner at a global law firm called Baker Hostetler. And finally, we have Kaylee Schroeder. Kaylee is Global Privacy Counsel at EPIC, which is a nonprofit advocacy and research center. Before we turn to our panelists, I'd like to take a minute to level set our conversation and offer a little bit of a historical context as to why we're talking about this agreement today. So as we sit here today, certain data privacy practices in the US are considered unacceptable to our counterparts in the EU. For years, US companies and organizations that have relied on data transfer across the Atlantic have been treated differently because of perception that our laws and regulations do not adequately protect personal data of people in the EU. The current EU concerns could probably be traced back to the passage of GDPR, the General Data Protection Regulation, that passed law in 2016. And GDPR revised a 1995 directive on the handling of personal data in the EU. So GDPR is viewed by many as a model privacy law because of its comprehensive approach. Contrast that comprehensive package with the approach taken in the US, which is a patchwork of federal sectoral and state privacy laws and regulations. So at its core, GDPR seeks an adequate level of protection from countries with which it exchanges personal data. And without this adequacy designation, an entity just has to meet more burdensome requirements, which can be challenging for many businesses and organizations. So while the US itself has not been deemed adequate, twice in the past, it has reached a compromise with the EU to permit these data transfers. And the latest iteration was Privacy Shield, which was a self-certification mechanism. But unfortunately, that was short-lived, and Privacy Shield, like its predecessor, Safe Harbor, were struck down by the European Court of Justice in 2020, primarily citing US intelligence practices as lacking clear and precise rules, and that they were not limiting collection of information that was strictly necessary. So that brings us to the present. Last fall, President Biden signed Executive Order 14086 to implement an agreement in principle with the EU on transatlantic data privacy frameworks. So this executive order, or EO, is groundbreaking in how it addresses data privacy concerns raised by the European Court of Justice when it struck down Privacy Shield. So the European Court of Justice primarily focused on situations like the vast intelligence collection or their perception of it, and lacking redress mechanisms. And this EO addresses those two pressure points that were problems with prior iterations of a data transfer mechanism. Though we have made tremendous progress towards a potential adequacy designation in the US, we haven't crossed the finish line yet. So that's why we are here today to talk about the possibilities of this new agreement. So that is the historical context that is quite important to talk about the future of this new agreement. So let's kick it off with our panelists, and let's hear from each of our panelists, going through each one, Beth, Jackie, Nicole, and Kelly. I would love to hear from each of you. Can you each talk about where your organizations are in this part of the story? Beth, we can start with you.
Sure. Well, good afternoon, and thank you for inviting me to participate in this very timely panel discussion. I'm especially grateful to MITRE and to Julie and to Dina for the invitation. As Dina said, my name is Beth Williams, and I'm a member of the Privacy and Civil Liberties Board, or PCLOB, which, as you probably know, has been given an important role in the implementation of the EU-US Data Privacy Framework. I should note at the outset that I am just one member of the board, and I'm speaking today in my personal capacity and not for the board as a whole. So I'd like to start a little bit, as Dina said, just by explaining about the background of the Privacy and Civil Liberties Oversight Board and its role in the oversight of US intelligence agencies and how it fits into this new data privacy framework. So PCLOB's independence, expertise, and reputation for fulsome reports and public engagement really make it an unparalleled institution for intelligence oversight, one that, as far as I'm aware, doesn't really have an equivalent in other countries in terms of transparency or independence. These unique characteristics enable PCLOB to contribute to the success of the new data privacy framework. The board was created by Congress in 2007 on the recommendation of the 9/11 Commission. And Congress gave us two tasks. First, to analyze and review actions the executive branch takes to protect the nation from terrorism, ensuring that the need for such actions is balanced with the need to protect privacy and civil liberties. And second, to ensure that liberty concerns are appropriately considered in the development and implementation of laws, regulations, and policies related to efforts to protect the nation against terrorism. There are 5 members of the board, including myself, and we're all appointed by the president with the advice and consent of the Senate. And we are considered an independent agency within the executive branch. The members are bipartisan, currently with 3 Democrat members and 2 Republican members. And we're supported by a nonpartisan staff of lawyers, technologists, and analysts with professional experience in both the intelligence community and in the civil liberties advocacy community, who all have the clearances that entitle them to access details of these programs that we oversee. And since its creation, as Dina knows well from her prior work with the board, the PCLOB has played a key role in oversight of US intelligence agencies. In particular, our reports on the FISA Section 702 surveillance program and the USA Patriot Act Section 215 bulk telephone records collection program have been considered critical to informing both Congress and the public of the details of these programs. The Foreign Intelligence Surveillance Court has relied and cited to the board's Section 702 report in its annual opinions reviewing the program. And we're currently working on an update to the Section 702 report that we expect will be published later this year in order to inform Congress's consideration of reauthorizing Section 702. We recently solicited public comments on the Section 702 program, and we had a public forum to discuss the program with government officials and civil society. Our work on the Section 702 program is especially important to the data privacy framework because of some European concerns over the impact of the program on EU citizens. So the board's record of effective oversight is really the reason that the EU and US governments have placed trust in the PCLOB to play a role in the EU-US data privacy framework, and why the European Commission's draft adequacy decision on the framework cites to the work of PCLOB. In accordance with the framework and the implementation of it through Executive Order 14086, the board has three main roles. First, the board will review intelligence communities' revised and updated policies and procedures to ensure that they meet the standards of the executive order. The agencies are required to implement any recommendations by the board or explain why they can't do so. Second, the Attorney General was required to consult with the board on candidates for the new Data Protection Review Court, and that consultation has actually already occurred last fall. And finally, the board annually reviews the workings of this new redress system created by the executive order. That is the Office of the Director of National Intelligence, Civil Liberties and Privacy Officer consideration of complaints, and then we'll review the CLPO's decisions by the DPRC for several elements to ensure that it meets all the requirements of the executive order. And then we'll provide classified versions of our reports and any recommendations to relevant executive branch officials and congressional intelligence agencies and communities. So the PCLOB is going to execute these responsibilities with the same diligence that we've applied to our work to this point. We're glad to have a role in this. We think we can play an important and independent oversight role, and hope that our participation will provide US and EU authorities and the public the confidence that their privacy and civil liberties are secure going forward. Thanks.
Great, thank you so much, Beth. Jackie, over to you.
Hi, thank you, and thank you for having me. In addition to the excellent overview that Ms. Williams had, I want to give a little bit of a spotlight on where CIA is in this. So in terms of timing, we're still working through the implementing procedures. The most recent document that's been put out publicly was the Intelligence Community Directive 126, which were the implementation procedures for the Signals Intelligence Redress Mechanism under the executive order. So where we are is working through that and then doing the internal documents that will further describe how that's being implemented. So we're still really in the new stages of this, but what I hope that you're getting from both the conversation that's already happened and the conversation that will continue to happen is we're building on existing mechanisms and adding new ones. So this should have a flavor of the familiar, as well as we're hoping that you all learn about some of the new redress mechanisms as well, and how that enhances existing mechanisms. So with that, I'll turn it to the next panelist.
Great, thanks, Jackie. Nicole, over to you.
Hi, everyone. And I will apologize, my voice is a little rough today. So, and I will also just throw out there that I'm speaking sort of my own opinions today and not those of my firm or any of our clients. But from my perspective, what we are mostly dealing with, representing a number of clients in the sort of private sector, is how to balance all these competing obligations on the data transfer piece, and in particular with the recent deadlines on using the standard contractual clauses and updating to that mechanism, along with the possibility of the new framework and what all of that means, and then throwing the pieces of the executive order into that. So we are currently just doing a lot of advising, and then I guess waiting and monitoring the situation to see how things unfold as the European Commission adequacy decision moves forward. So I'll send it on to Callie.
Great, thanks, Nicole. Callie, over to you.
Hi, and thank you for having me. I work for EPIC, which is the Electronic Privacy Information Center. We're a nonprofit that works in research and advocacy around privacy and civil liberties issues. We have done some work with Max Schrems in the past, so we've definitely been talking with him about thoughts on the framework. And before I worked at EPIC, I also did client compliance work and briefly worked for the Federal Trade Commission. So I'm trying to have a perspective on this framework that's looking at practically how useful it is, and also looking at whether it can stand up to what Europe has been saying when it comes to US surveillance and how that's holding up against EU individual liberties. So that's the perspective we're bringing to it. We have some thoughts on the framework. I think a lot of it has been a major improvement, and it's very clear that whoever drafted this framework absolutely had in mind the decisions of the European Court when they were drafting it, and specifically tried to address problems. I'm not certain that it goes as far as Europe would like it to, but happy to talk about it and excited to hear perspective from the other panelists.
Great, thank you, Callie. So that's where each panelist and their organizations are in this story. And before we get into the meat of the executive order, I like to ask, again, all the panelists, just another broad question, more of kind of a philosophical question, but it really gets to the heart of, why we've had these fits and starts with this framework. And that's the way that the US and the EU approach data privacy. So as we all know, in the EU, they have codified a fundamental right to privacy, to personal data. The EU, in the US, it's not quite analogous as that. There is no fundamental right to that, but we do have laws that protect privacy and data. So now that we have this new executive order and this new framework, tossing out there to any of the panelists, do you think we can now look at this new framework and this new path towards adequacy as a way of the US getting a little closer legally and philosophically to how the Europeans view privacy?
I'll jump in really quickly on that. I think that it's encouraging that the framework is clearly taking into account what the global perspective on privacy is, and bringing in some more of that European perspective that privacy is a fundamental right. In our work, we certainly are pushing for the idea that privacy is a fundamental right. I don't know that the framework itself is going to shift that much, because it is very geared towards European data protection rights, and the possibility that US citizens would be able to take advantage of momentum there or take advantage of the systems there, I think only go as far as codified rights go in the United States. So if there's different state rights to privacy, then it can help a little bit in that perspective. If there's different federal laws on privacy, it can maybe help enforce those. But I don't think this necessarily creates codified privacy rights for US citizens. And I think we would need several additional steps to kind of meet that level where and ensure that American citizens have the same kind of privacy rights that European citizens do.
Right. No, excellent points. It's not just a one-size-fits-all solution. It's going to be a series of efforts over time. Nicole, anything from you?
Yeah, I was just going to hop in and say too that I do think it's encouraging to see the executive order, and to also see some of the movement that we've seen around the possibility of a federal privacy law, which does seem to have some momentum. And I do think there is quite a bit happening in the sort of the private commercial space that has been pushing for that, and wanting to see a little more consistency and predictability, I think, in terms of US privacy law, and the ability to kind of see more of that align, I think, potentially with the EU, just for purposes of making everything a little bit not even necessarily easier to meet the metrics, but easier to develop a program that would get you there, at least in a single program, which has been a concern for a lot of global clients, I think, over the past, I would say, 5 years or so now, with the run up to GDPR and then all the laws that we've seen following that, sort of globally. It's been an issue, and I do think there is some encouragement to see the US at least pulling some of those thoughts and pieces in a public way into something, even if it's aimed at Europeans, that we are willing to come out and say, that we will meet them in the middle on those pieces.
Great. Thanks, Nicole. Beth?
Yeah, and I would just add, look, the U.S. Constitution obviously contains privacy protections. In terms of government surveillance, in particular, the Fourth Amendment, as interpreted by the Supreme Court, is quite protective of privacy. And of course, laws enacted by Congress, most importantly, FISA, were designed to and do provide further protections. So Americans' data protection, certainly vis-a-vis the government, is relatively strong. Whether Congress will pass additional laws to further data protection for Americans with regard to the private sector is obviously something that has been a topic of repeated discussion, and I think was mentioned. The other thing I would just point out, though, with regard to this new framework, is that the redress mechanism that's going to be available to complaints transmitted from qualifying states. And those are states that are designated by the Attorney General based on, among other things, the conclusion that the states provide appropriate safeguards in the conduct of their signals intelligence for U.S. personal information. So that's a really, I think, interesting and important aspect of the new executive order and the new framework. And it does provide the U.S. government an additional way to protect U.S. persons' data vis-a-vis other governments.
Mm-hmm. And that's a great segue, Beth, to the next question I have, and that's just getting right into the meat of the executive order, and that's the changes it has to intelligence gathering. Jackie, I'll pivot to you for this since you work on this on a daily basis. So the EO specifically focuses on the personal data collected through signals intelligence activities. It's a very narrowly drafted executive order based, it's even in the title, signals intelligence activities. So can you give us a baseline understanding of what signal intelligence activities is and how that relates to our personal data?
Sure. So signals intelligence, also known as SIGINT, involves collecting foreign intelligence from communications and information systems and then providing it to customers across the U.S. government. So examples of this would be senior civilian and military officials, or even our policymakers. So they use that information to protect troops, support allies, fight terrorism, combat international crime and narcotics, support diplomatic negotiations, as well as other important national security objectives. It's collected from various different sources. Some examples are communications, radar, and other electronic systems. So from that, you can probably see, okay, communications, there's a lot of personal data in these different types of items that are collected through signals intelligence. And I think what's important here is that the personal information is minimized through this executive order only to that which the policies and procedures allow. So the executive order requires that the different agencies, so each element of the intelligence community that handles this type of information has to create policies and has to create procedures that show how we're minimizing dissemination and retention of this personal information. So there's specific requirements for both dissemination to minimize who can get it. So for example, you cannot disseminate the information solely because of a person's nationality or their country of residence. And there's even limits on the reasons for dissemination within the US government. So it has to be only to an authorized and trained individual. And there has to be a reasonable belief that the information will be appropriately protected and also that the person has a need to know. So you can't just share this information without the recipient having protected it as well. So there's a lot of different ways that it's protected in that dissemination of the information. And that is taking into account that, no matter where you're from, you inherently have some privacy rights. So it doesn't matter if you're, a foreign national, this executive order is saying we are still going to protect the information collected through signals intelligence.
Thanks, Jackie. And just pulling that thread a little bit, even though you're still in the early stages of trying to implement and understand this executive order, do you see any initial challenges or hurdles in implementing some of these changes?
I think, really, because this is building on an already strong and robust ecosystem of protections that have been in place, especially for Executive Order 12333 and a lot of experience with FISA. I think that this is really just adding on to that. So I don't see us having the same hurdles that we would if there were an entirely new rule, but I see this as really building out a more robust foundation and a robust mechanism that is going to extend some of those protections even further. So the real challenge is always getting things on paper, and then once we have the first complaint come through and have the process actually gone through and completed, I think that that's going to be the hardest part, is just getting the first one through and making sure that all the bells and whistles are aligned and that we're really doing justice to the purpose of this executive order. Great.
Thanks, Jackie. And Callie, a question for you. You earlier mentioned your team has been in touch with Max Schrems, and for those who are not aware, Schrems is an advocate who's partially responsible or the impetus behind the invalidation of Harbor and Privacy Shield. So knowing the concerns that invalidated those decisions in the European Justice and seeing these changes to the collection of intelligence in this new executive order, do you think the necessary and proportionate challenges to the prior iterations of this framework, do you think those are addressed with this executive order, or do you think we could go even further?
I think that there was care taken in this framework to try and address those issues. I don't think they've been properly addressed. For example, one of the allowances that still allow bulk collection of data is protecting against threats for personnel of the United States. Under the definition of personnel of the United States, I think I'm using the right term. Let me double check that. I want to make sure I'm using the exact right terminology there. Yes, personnel of the United States. The definition includes anyone that works for or previously worked for the United States government. That would include me. It shouldn't. I'm not important enough to be an impetus for bulk collection. But I used to work for the Federal Trade Commission. So technically under the definition, I would be a personnel of the United States. And if there was a threat to me online, then that could justify bulk collection of data. I think that that exception is hopefully unintentionally just far too broad as a justification. And the EU tends to be extremely leery of bulk collection in general. So when there are exceptions, even when there's attempts to keep them tailored, they have to be really carefully examined and there have to be strong protections against misuse there. And I think a few of the exceptions are ripe for misuse. Another problem with the necessary and proportionate issue there are that there's a possibility for presidential discretion in shifting what some of those categories are. They could be broadened in the future, and to the rule or the language within the framework, they wouldn't necessarily need to announce the reason for expanding those categories. And I understand that to some extent that's a degree of discretion because there could be circumstances where you need to keep things under wraps or keep things a little more secret if there's major security events going on and there need to be adjustments. But I think that is a problem that's going to come up because while there is valid reason for potential expansion of exceptions to the limitations on data collection, there's also potential for abuse and misuse. Another problem that I think is going to come up within the EU, and particularly Max has discussed this being an issue, is that the redress mechanism is extremely complicated and also doesn't necessarily allow people to get information on whether they're being surveilled, and doesn't allow them to argue for themselves. In the process, initially they bring a complaint to their supervisory authority who then submits the complaint. So they're not really able to draft the complaint themselves there, or not necessarily. The authority that they go to could just draft their own complaint and send it in. If they do appeal the decision, then they're assigned an advocate, and they don't get to select that advocate. They don't necessarily get to communicate with them or make arguments with them. So in some ways, protecting their rights is fully out of the hands of the individual that's affected here. I think those are going to be serious concerns when it comes to evaluating whether this framework is going to stand up to scrutiny from the EU. Again, I don't always want to be the doom and gloom person when it comes to privacy. And I do want to recognize there definitely was effort here, and people have tried very hard to make sure that this is going to stand up and be a stable framework. I just don't believe that it's going to go as far as Europe wants it to. And I think that could be a serious sticking point.
This might be a good time to pivot to an audience question. Paul Burdett with the Senate Foreign Relations, he says, does Section 702 get at the core of the EU concerns? And it's an appropriate time to discuss 702 because, as you know, it's up for reauthorization this year. Tossing it out to whoever wants to pick up on that response.
Well, I can jump in here and just say that I think, in a way, yes, Section 702 is core to some of the concerns. But depending on which regulators you are talking to in the EU, it's certainly not the only concern. In terms, like, we've seen a lot of questions, for instance, around the Cloud Act in the context of doing things like, so we've been working with the standard contractual clause process a lot for clients, which involves a transfer impact assessment piece. So we've been looking at that for a lot of clients who might be subject to 702, but also getting requests to look at, are they subject to the Cloud Act? How might that work? What can they do around that piece to protect as well? So there are certainly other concerns. I would say Cloud Act's probably the other main one that gets lumped into the surveillance pieces, along with sort of the executive orders and various other things. But yeah, Cloud Act in particular seems to be one that has come up in a lot of contexts recently as of concern too. But I think Section 702 is probably one of the main ones discussed by the Court of Justice of the European Union in the actual decision. Cloud Act itself, I don't believe ever shows up in the Schrems 2 decision, but has been brought up by a number of the regulators. I think primarily the German regulators, but a few others have probably brought it up as well.
Yeah, and I would just jump in to say, I mean, I guess a couple of things. One, I don't know that all Europeans can be painted with one brush, right? There's obviously the European Court of Justice, but there's also member states, and certainly the member states have, privacy concerns, but they also benefit from the efforts of the U.S. government to protect national security, not just of the U.S. homeland, but also of our allies. So there are, competing thoughts and concerns and many different strands of thought within Europe itself. I think the second thing is that, 702 is not a bulk collection program. It is a targeted collection program. And so I think while it is certainly on the radar of some of the folks in Europe who have privacy concerns, I think, as Nicole said, it's just a part of it.
Great. Well, thank you both for those comments. And Beth, since I have you on the spot, I know in your opening comments you talked about what PCLOB is doing to prepare for its new role. But could you just dig a little deeper and let us know, if you're able to, how is everyone at PCLOB receiving this new scope and authority? What are you doing to prepare for it, both in terms of organizationally and maybe otherwise?
Sure. So in his executive order, the president asked and encouraged the board to expand our oversight role, as you mentioned. And the board has stated publicly that we'll agree to take on this new role. And indeed, as I mentioned before, we've already begun, because we've already been consulting with the Justice Department and the Attorney General on new appointees to the Data Privacy Review Court. I think really crucially, no nominee to the Data Privacy Review Court can be a current government official. So that's a key difference in how it currently works with one ombudsman who is a government official. So the U.S. government took a big step with this executive order, reaffirming the privacy and civil liberties, has been said, not just of U.S. citizens, but of, all people. And the Privacy and Civil Liberties Oversight Board is certainly committed to playing our part in the oversight process to ensure the framework functions well and as intended. All that said, we're really at the very beginning, because other than talking with the folks at the Justice Department and giving our input on the Data Privacy Review Court nominees, we haven't yet received the new draft policies from the IC. And so as soon as we do, we look forward to reviewing them and hopefully providing helpful feedback as soon as we can.
Great, thank you, Beth. We've kind of talked at length about the change in collection of intelligence activities and oversight mechanisms, but redress is also one of the pain points of this new executive order, both positive and negative. So with redress, there's a very elaborate two-tiered mechanism. The intent is to be independent as compared to the previous iteration of the Privacy Shield Ombudsman, which was not seen as independent because it sat within the State Department, among other reasons. Nicole or anyone else on the panel, can we talk through a little bit more about this new redress mechanism and how it may achieve that level of independence that previous iterations of redress have not achieved?
Yeah, so I can just jump in. I think Beth sort of touched on it with the idea that part of the new redress mechanism. So we have the two-tier, moving from a single-tier government official model to a two-tier model under the new framework. So the first layer will go through the Civil Liberties Protection Officer, and then the second layer through the new I guess, court system of sorts. What do we call it? The Data Protection Review Court. I keep thinking of things by acronyms and trying not to use them. And so that is aimed at, I think, addressing both the independence piece, since, as Beth noted, they're looking for people outside the government framework to appoint to that court, and then also the binding authority piece, which was another part of the redress mechanism that came up in Schrems too, that they felt that the ombudsperson did not have a binding authority to make those decisions. So the new two-layer piece, in some ways, that first layer I think is most similar to the sort of mechanism that we currently have, and then it adds on the second independent court piece that will have a binding authority. So addressing both of those pieces, I think, is helpful. As I think Beth has noted as well, there's a lot to get figured out yet, and exactly how all those are going to work. And then I think it was Jackie that mentioned, shepherding the first few through that process is always, anytime you're going through a first process, it's always a little bit of trying to figure out the system and exactly how it's going to work. But I think there's a lot of thought that's been put into how that redress mechanism is going to work and how it could function within existing sort of structures.
Any other panelists to talk about redress?
I raised some of the issues earlier. It is a multi-step process, which in some ways is good. In some ways, that means that it spreads out the process in a way that can lead to more independence and more accountability and multiple checks and balances within the system. So in some ways, that's a good expansion. The issues that we see with it are that because of the structure of the process, individuals really get cut out from the process once they make their initial complaint. So they're not in control and not really able to fully participate once that initial complaint goes through. It's the initial complaint, it's then submitted by the qualifying state. Once it goes through that process, if it gets appealed, then there's an advocate that's arguing on their behalf, and the advocate is the one that gets the information and has the actual interaction with the process. The individual doesn't. And some of that's for security purposes. I understand that. Some of that is because there may be things discussed when going over a surveillance case that individuals are not cleared to know. And I understand that process, but it is still a problem that individuals really can't own their own data rights in this process. And one other consideration is that this structure still is largely within the executive branch. And again, I understand why it's structured that way, but that was a complaint that was raised in some of the initial invalidations, that there's some question about whether there's true independence and whether there's true redress under a system that is all under the executive branch, where theoretically a member of the executive could step in and just say, there may be a problem here, there may have been some rights violated, but there's not going to be a redress for this particular violation. So I think there may still be some questions about adequate independence in the system.
And go ahead, Beth.
Yeah, I would just jump in. I think, one aspect of the redress process that just hasn't been discussed yet is that the decisions of the DPRC are going to be binding, as laid out in the executive order. And so, certainly understanding Callie's concerns that maybe they wouldn't be binding. Maybe you could write a new executive order that turns it around. As this EO lays out, this EO says that these decisions are not just advisory, they have to be binding. And then obviously the board will have a role in making sure that the decisions are carried out by the IC. So that certainly goes a step further than I think has ever been taken before.
And Jackie, over to you.
Yeah, I mean, I think that this is the most significant redress mechanism that's ever been in place. It hasn't been pressure tested yet. I do think, there are things that we will learn once it is, but you have to think about protections as, as redress is one type of protection and one mechanism, but this executive order also calls for significant different oversight mechanisms, whether that is, the general intelligence community oversight or inspectors general. There's still the privacy and civil liberties officers at the various different agencies. And there are requirements that they have all the information that they need to be able to actually determine whether or not there is an appropriate use of the data. And so I think that we have to think about it beyond just, redress, and also consider that, there are protections on the front end of what can be collected in the first place. There are, restrictions on the use of that data, the dissemination of that data. There's oversight, and then there's also this redress process. So there's, I used the term ecosystem before, but there really is, much more to protecting data than just the new part that we have here. So, again, it hasn't been pressure tested, and understanding, some of the concerns about where it is. But I'm hopeful that when it is pressure tested, what will happen is that we will see more redress than we have ever had before, and we'll maintain that adequacy determination. The other thing is adequacy can always be withdrawn. There have been documents that have come out saying, this can be withdrawn if we understand that the rules have changed too much, or that the government in the United States is shifting directions in a way that, is not commensurate with the adequacy decision. So I do think that there are some checks and balances, even with that ability to withdraw adequacy that has been publicized. So there's so many different mechanisms within this, and it's really easy to focus on one part. But I do encourage the audience to try to think about it as a bigger picture.
It's a great point, Jackie, because as long as it takes to get adequacy, it probably takes equally as long to lose it. So there's that silver lining. But for Callie and Nicole, because I don't want to put our government panelists on the spot, if you could have the power to make your own red lines to this executive order, what would they look like?
I think it's dangerous to give us redlining opportunities. I would really love for there to be just no bulk collection permitted. I understand why people want it. I'm an advocacy organization. I just don't think that bulk organization is justifiable in many cases, and in the few where it may be, I think it's prone to abuse. I would love for the redress mechanism to allow for individuals to advocate for themselves and to have a little more access to information about what's going on with their information and what's going on with the surveillance in particular to them. I understand that there may need to be some restrictions or retractions there, so they're not getting too much insight into national security situations. But I think empowering individuals as much as possible is important. I would love for all of that to be extended to US citizens as well. I would also love for this to be, I understand why it's structured this way. I would love for this to be a law and not an executive order, because it does fall prey to some concerns about stability when it's an executive order. Executive orders can be shifted by administrations as they change in and out, and they can be shifted by existing administrations. I think that there's a lot of adaptation and change that could be possible depending on what incoming administrations want to do with this executive order. Hopefully, if it's a good working system, if it gets an adequacy decision, people won't want to touch it and mess with it. But the stability issues there, I think, are a little concerning. So in an ideal world, I'd love for it to be a law and not an executive order.
And a law that has the right appropriations and not just authorization behind it.
Yes, I would like that to be fully binding. I want all of the support there. I'd love all of that.
Great. Nicole, over to you.
I don't really have a whole lot to add on top of that. I think I will sort of generally agree with Callie. I think I don't know that we would necessarily be able to get there on a lot of the individual request pieces, but that does make me wonder as well if there couldn't have perhaps been a little more transparency or even transparency reporting obligations within it that would give people a level of comfort with their knowledge of what was happening, knowing that this is still somewhat of an opaque process for the average person. Very much echo that I would have liked to see this as a law instead of an executive order. I know there's been a lot of concerns on the European side, and it's been talked about quite a bit, the fact that executive orders are easy to get rid of. It would have been nice to feel like there was a little more security around this.
Nicole, sticking with you, since we're talking about security, and not asking for any legal advice here, because I don't want to get an invoice from Baker Hostetler. But talk us through what you say specifically to your clients. If they're asking to be prepared to apply for new, say certification, or if they have to change their policies or processes, how do you give them advice? What do you say to them while this uncertainty is happening?
Yeah, I think in some ways we're not exactly sure what the sort of exactly what they're going to have to do for self-certification under this one. That said, there is quite a bit of alignment between having similar types of principles in place. So on one level, you can look at what are the principles under the new framework and start aligning your practices with those. I think especially for clients that are not currently GDPR compliant or haven't really done a full GDPR compliance program, that those, in order to be able to make use of any new framework once it's gone through the adequacy process, they will need to be able to meet and publicly represent that they meet and show evidence of those particular principles. So starting to think of where they might be falling short, especially on some of the ones that are a little more time intensive to implement, I think is a really good thing for people to be doing right now if they are thinking that they want to be able to sign up for the new framework. And I think that that's probably where we're getting a lot of questions right now, is around should we be thinking of this? There's a lot of concern that this framework might also, we've got a lot of clients that we counsel, a lot of people who ask us that have, they've been through Safe Harbor, they've been through Privacy Shield. Now they've had to go through the process of, switching their contracts over to SCCs, many of them, using the standard contractual clauses instead. They're like, oh, why should we even be dealing with this framework thing? Is this a good idea for us? And I think a lot of that really depends on where, what the company's situation is and what the expectations I would say a lot of the people that we work with that are really looking forward to the new framework are the types of companies that are processors for a lot of data controllers in the European Union, who are getting a lot of data flow and really are it's not that they can't do the SCCs, it's just that is such a process for them to be doing them over and over and over again for a lot of different clients that they are really sort of looking for that framework piece. But I think a lot of the clients that would have typically relied on something like the Privacy Shield framework in the past have already gone through the implementation of so many standard contractual clauses now that they may be not so interested in the new framework. So one thing that I think a lot of them were very happy to see was the fact that the executive order pieces also apply to the other mechanisms, like the standard contractual clauses that are available for the data transfer. So it's not like you have to sign up to the framework to be able to have access to, for instance, the redress mechanism and various other things. So I think that was something that a lot of our clients were very happy to see. We were very happy to see as well, because I think there was some concern that you might have to be in the framework to have those to have those apply to your data transfers. So.
And that's a good time to pivot to another question we have from the audience, and it's anonymous, but I suspect it's from a MITRE employee, because the question says, what do the new requirements mean for MITRE? And to expand upon that, MITRE is a nonprofit organization. Does this new framework, would it apply to every single company and entity trying to exchange data with EU, or are there carve-outs? Nicole, I guess I'll turn to you.
So it would not necessarily apply to every single company. A lot of companies could sign up for it. The obligations under the framework themselves, if you sign up, would fall directly on your company. And then there are also obligations on onward transfers. So for instance, if MITRE was working with a company and receiving data from that company that had gotten the data through the framework, then you might have obligation. I believe one of the obligations, for instance, under the onward transfer piece is that if you are getting data that has come under the framework to you as part of an onward transfer, you have an obligation to report back within the framework mechanisms if you can no longer protect it in accordance. And there's some pieces that have to go into the contractual agreements around that too, that are similar in some ways to what we see with onward transfers under standard contractual clauses. So some alignment there. I think that's one piece to pay attention to.
So keeping you on the spot, Nicole, if you don't mind, you're on a roll here. Let's keep going.
Yes.
So we keep talking about this EU-US relationship, right? But
Yes.
The US has a lot of business with the UK, and the UK is no longer part of the EU. So what would that mean for US-UK economic relationships?
So the UK, I believe, is separately evaluating the framework at this point. Anecdotally, the last I heard was that they may actually be on a faster track to an adequacy decision on the framework than the EU is. They're the process that the UK has in place is perhaps a little bit less. Fewer steps in it, I think. So if they can actually possibly fast track it, we may see an adequacy decision for the framework out of the UK before we see it out of the EU. And I know a lot of people ask about Switzerland too, which is its own different system, but they usually follow the EU. Switzerland usually follows the EU in terms of their adequacy decisions. So they typically accept the EU adequacy.
And there's a question from the audience, a gentleman named Joseph. I'm sorry, I can't see your last name in the chat box, but Joseph asked, when can we expect an adequacy decision to be made? I think last I heard was probably this summer. Have you all heard anything different?
I don't know that they've given a formal indication of this, but based on the last couple of adequacy decisions, I think summer is, I think the last two have ranged from sort of 4 to 6 months to get through the full process in the EU. And we got the draft adequacy decision, I think like mid-December 15th, I think roughly. So yeah, so I would, my best guess would be 6 months, 5 months from that date. So probably looking at early summer. I don't know if anybody else would like to. We can all place bets on that date right now.
Summer's what I've been hearing as well, and yeah, I would think it would be more on the 6-month range rather than the 4, based on the healthy debate that I've heard there is over the proposed framework. So yeah, I would also say early summer.
Yeah, we do know that, I mean, as far as the process, where the process is right now, the European Data Protection Board is working on their opinion. Their last agenda for their, I believe this is last week's plenary, stated that they were discussing it at that point. So, so it is actively under discussion, we know at this point, so.
You know, another great bet, talking about bets that we all can make, I guess, is how long will it take before there is another legal challenge from a Max Schrems or a DPA or someone else, right? I've read about Max Schrems and his group being dissatisfied with the framework. I think the Germans might not be terribly pleased with the current language. Anyone want to talk about their thoughts when one, a challenge will be made, and 2, could the challenge come through this time, or will this framework withstand the threat of a challenge?
I mean, challenges are already in the works. They're already being drafted. I don't necessarily know from Max, I would imagine, because he's been involved in previous iterations of this. I do know that he is hoping to be able to turn his attention to matters outside of data transfers. So he may be trying to pass the torch to someone else at this point. But I mean, his organization does a lot of work specifically in this area and in protecting EU data rights. So I know that they've done very careful analysis of this framework, and I would imagine that they're drafting a potential challenge if this does get an adequacy decision. There's multiple other groups that are also considering it. As you mentioned, there's DPAs in Germany and in a few other places that are carefully considering whether they should challenge the framework. I would guess that the challenge is most likely to come in an individual or advocacy group capacity, and then it would be pushed by different DPAs. It's at least in my understanding and in my experience so far, it's rare for DPAs to submit a challenge themselves outside of the debate process that's already happening for the adequacy decision. That doesn't mean it couldn't happen necessarily. But I think if an adequacy decision happens, you will basically, the day it's announced, have challenges to the framework go through. I can't say for certain whether it would be invalidated or not. I know that DPAs, individual companies, the US government are all really, really making a lot of effort in having a stable framework that we can move forward with. Nobody likes the system of having a framework in place, putting in a bunch of effort, and then having it invalidated every few years. You don't want this to be a continuous forever cycle of always having another framework come up. And the uncertainty is not super helpful for businesses, certainly, but also extremely unhelpful for individuals who are never quite certain what redress they have and what protections they have and what's in place. So I think stability would be good for everyone. I just don't know whether this framework is going to be what delivers it or not, but I think it's definitely come a long way from the frameworks we've had in the past.
Yeah, I'll just add that I think that whatever opinion we see from the European Data Protection Board will probably signal in some ways whether they think there are still concerns. I think that DPA concerns with the framework will likely show up in some capacity in that, not necessarily named, but as part of the, you know, these are still the concerns that they're seeing. I know that a lot of the advocacy groups will be following that decision very carefully as they are sort of teeing up any challenges they have, but I would not be surprised to see Max Schrems and his nonprofit get involved. I know some of the others, Digital Rights Ireland has been pretty heavily involved in advocacy pieces around some of these things. So there are a number that I think we could expect to see, and then it's just really kind of a matter at that point for whether or not the DPAs again sort of refer those questions up to the Court of Justice of the European Union, and how they decide to, you know, how they decide to handle those, basically, you know, at what point they are looking at, you know, they'll be looking largely, I'm guessing, at the same things that were problematic under the last sort of the last two iterations, and whether they ultimately can decide that it's close enough, that we've gotten close enough to whatever it is the court was ultimately looking for on those, which I am not going to hazard a bet on. So.
Yeah, and I'll just add in that I think, the US government's position has been there are certain limitations in law as to how far they can go, especially with regard to the redress mechanism. And so I think the drafters of this framework tried very hard to address the concerns that were at issue in the Schrems II decision. And so one big question out there is just, whether the goalpost will be moved, or whether the further requirements are even able to be met under US law, under the position of the US government. And so all big questions, but I think I agree with Callie that this is a huge step in the direction of more data privacy for all citizens.
Great. Well, we're getting close to the end of our time together. I want to come full circle. And in the beginning, we talked about where each of your organizations are in this story. I love to end hearing from each of the panelists what your organizations think are next steps and what you're doing to prepare for this new world order in privacy. Beth, with you first.
Sure. So, we're happy, the board is happy to be part of this process because, like I said, we play a really, I think, important and unique role in increasing transparency and being a check on the systems that are in place. And so we're happy to receive the new policies as they're drafted from the agencies, provide feedback and work to make them as privacy protective as possible, and then also to help do the annual reviews of the new redress mechanism and the data privacy review court when it gets up and running.
Yeah, and we're still working on writing some of those internal policies that Ms. Williams mentioned, and making sure that we're working with our oversight to tighten them up and strengthen them to the extent necessary. So that's where we are in the story. I don't have much else to report, but we are standing ready to respond when there is a complaint and make sure that there are adequate processes and procedures in place to resolve those. So I'm frankly just intellectually also very interested in seeing how this will actually play out. And I think that it's an important mechanism to augment the existing privacy and civil liberties protections that we have and the oversight roles that we have in the intelligence community agencies.
Thanks, Jackie. And over to you, Nicole.
Yeah, I mean, I think we're kind of at the same place on this one of the sort of watching and waiting, but I think we're starting to get more questions. I think once the draft adequacy decision came out, questions from various clients started coming in about whether this was something they should be looking at. So a lot of it is talking through and helping them think through, like, is this something you should be looking at? How can you start to prepare? How can you leverage work that you've already done around your existing privacy programming internally to meet the obligations that you might have to have under the framework? And then just personally, I think it'll be really interesting to see how the Data Protection Review Court goes forward and how it might get used, because it does seem to have the capacity to be used outside of this specific framework. And I'm interested in seeing some of the ways that might be leveraged in other capacities, I guess.
Great. And Callie, you can just bring us home.
I agree. I'm very excited to see how this works in practice and how it goes from text and theory into practical application. I think that's going to be a really fascinating process to watch, especially as we hammer out the kinks in the process and hopefully are able to be semi-agile and adapt to concerns that may be raised as the process works its way through. We're, of course, keeping an eye on what the adequacy ruling will be. We're keeping an eye on challenges. And we're also speaking both with advocacy groups based in the EU and in the US, but we're speaking with individuals and trying to get a sense of what individual EU citizens think of the framework, whether they think there are weaknesses, whether they feel like their rights are being adequately protected, and what the next steps are there. And then personally, I'm really curious to see if these kinds of data privacy protections and the focus on data privacy protections for international residents carries over into a US perspective and hopefully provides a little more momentum for some of the proposed federal privacy regulations and protections that have come up in the US. I'm excited to see where that goes.
Great. Thank you, Callie. And thank you, everyone, for being part of this conversation. It sounds like we just need to get our popcorn and keep an eye on how things are going to develop. And thank you to our audience for joining us. We hope you enjoyed this conversation. Again, our panelist bios are on our registration site. And if you'd like to reach out to MITRE to learn more about this or other programming, please contact us at privacy@mitre.org. Thanks again, everyone, and have a great day.